has just arrived. Ed Higgins, who is apparently familiar to some of you, is a graduate from the University of Montana Law School. He went to Humboldt State as an undergraduate. He is the triage attorney at Montana Legal Services, which I know is an interesting job. He has been there, and he has been at Montana Legal Services since 2001. So I'll go ahead and pass it over to you.
All right. I want to turn this thing. So I think I turned this thing on.
Yes.
Those of you here in the room, I'm sure will have no trouble hearing me, because I wasn't always a lawyer. I was a PE teacher for a while, and I like to yell at people. So, are you laughing at me being a PE teacher?
I think that's an awesome transition.
Well, I was actually a history teacher who taught PE. How about that? So I'm here to talk to you about something that's a little bit dry, limited scope representation. And it's the last thing in the afternoon, so I will try and be quick. I may try and be funny on occasion, but I'll err on the side of quick rather than funny. I guess one question that I ought to answer for people is, what makes me qualified to talk about limited scope representation? And the answer I would give you is twofold. One, it's pretty much all that I do. And two, I kind of think everybody should do some of it. So those are my qualifications. Let's talk about what is limited scope representation. It's anything less than full representation is limited scope. Everything from, well, you can read the list. Writing a demand letter, maybe providing advice at some sort of a clinic, reviewing somebody's forms or documents. Any piece of representation that you can break off and do discreetly would be limited scope. I think it's also important to talk about what's not limited scope. So getting fired by a client does not mean you were doing limited scope until you got fired. Firing a client does not mean you're doing limited scope. And stopping doing the work because you're not getting paid is not limited scope. The idea here is it has to be intentional, and these are all, well, other than firing a client, these are all not intentional things. You have to, really for it to be limited scope, you have to set out with the idea that I'm going to do something discrete for a client. And it's not just your intention to do it, it's the client's understanding that you're only going to do something limited. So, how do we know if it's limited scope? The first one is the most important, and that is that you and the client have agreed in advance about what it is you're going to do. That you're going to provide that specific service, that you're not going to do anything else, and you've also agreed on what the client is going to do. There are a number, if you go out on the internet, you can find a number of model retainer agreements for limited scope representation. And some of them are incredibly detailed, and it's like 4 pages of check boxes, and it's got an attorney will, client will, and you check the box for who's going to do which one. And it's crazy in depth about how detailed, when you get into 4 pages of check boxes, it is about who's going to do what. But the important part is that you've agreed in advance about what it is you're going to do and not do. And again, it's kind of, there's this rule 1.2 that says you should have this in writing about what you're going to do and what you're not going to do. So, is it really okay to do limited scope representation? The folks that were behind the changes in the rules to specifically allow limited scope representation would tell you that the Montana Rules of Professional Conduct have never banned limited scope. It's never been not okay to do it, but a few years ago when the rules changed, it became specifically okay. In other words, it used to be something that there was no rule that said you couldn't do it, but now there is a rule that specifically says you can do it. So there is in the field of limited scope stuff, a lady out of California named Sue Talia. And she runs her whole practice on this idea of limited scope. And she makes, I think, what she would describe as quite a comfortable living at it. But when she found out what Montana was going to do back in 2011, I guess it's more than a few years, being 7, that's more than a few. She wrote this article, which is in the handouts that you have, by the way, about what it is that Montana did and why it was so important. And especially at the time we did it, and I think still today, we really set up this scheme where it was okay to do limited scope, and not just okay, encouraged, and the rules very nicely allow us to do it. And if you're interested at all in limited scope, Sue Talia's article is well worth a read. And I really just like the fact that she said that Montana set the gold standard, because it's nice to be the best at something, right? But the article is actually very short. It's 2 pages long, totally worth a read. There's a little quote from it where she says, how great we are. We're great. We're great in Montana. So that article is worth a read. I was before I came here, actually helping teach a class upstairs. And the instructor of the class asked me to tell the students what I was going to come do when I was done with them. And one of the students said to me, can you be sued for malpractice if you're doing limited scope? At least one person in the room thinks that's funny. And I said, you know, there is that darn presumption of competence. I hate that. I wish that people would not think that I was going to be competent every time I opened my mouth. But it's in the rules. I'm presumed to be competent, as are all the rest of the attorneys here. And it does turn out that you do need to be competent. And in fact, there's an ABA handbook on limited scope assistance. Who knew the ABA would have a handbook on how to do it? But they stress in the handbook very, very strongly that you have all of the same duties if you're doing limited scope that you would have if you were doing full representation. In other words, just because you might be taking on half of the representation doesn't mean you get to do it in a half-ass way. You have to do it. You have to do just as good a job at that half of the representation you're doing as you would if you were doing all of it. So, why would anybody want to do limited scope? Well, if you do something other than what I do, money is often a big motivator. And what I think sometimes gets lost in the discussion of limited scope, because if you listen to me, people like me talk about it, they're always talking about how you can do pro bono as limited scope. But what really gets lost in it is something that I said about Sue Talia's practice at the very beginning. She makes a very comfortable living at it. She makes a lot, and by that I mean, she appears to make a lot of money at it. And it's because one of the reasons is that you can get paid in advance, right? And anybody who's ever been in private practice, and I'll confess I've never been in private practice, I've just watched people in private practice. My father was an attorney in private practice. I guess he's still an attorney in private practice, although he doesn't practice much. But I watched him not collect a lot of fees, right? You do a lot of work and you don't ever collect fees for it. But with limited scope, because you're sitting down with the client ahead of time and you're agreeing as to what you're going to do, it is very easy to say, I am going to do X, and X costs Y dollars, and pay me up front if you want me to do X. So, you know, if you had an exclusively limited scope practice, you would have no unpaid fees because you get paid up front. So money is a real reason to do limited scope. And I made the point that it doesn't compete with full representation, it augments it, but the thing that I see is when you look at the way society is headed and we're all connected and people want quick something, being able to say to folks, not, I'm going to represent you through this whole case and we'll hope for a particular outcome, but I will do X for you and give that to you and you will have that within this period of time, really it allows you to control the workload and figure out when you're going to be busy and when you're not going to be busy, and not be operating so much at the whim of a court or a client who's going to demand something. So it provides a way to control the workload. Why would a client want limited scope? Because they can afford it. It's much easier for somebody to come in and say, okay, I want you to write me a demand letter and I'm willing to pay you for 2 hours worth of work to do that, than to sign on and say, well, I'm not sure how much it's going to cost you to sue this person. We're going to start with a demand letter and whatever it takes, I'm going to pay you for that. It's much easier for someone to sign up and, just as it's easier to say to somebody, this is going to cost you $400, it's much easier for someone to say, I'll sign up to pay $400 than I'll sign up to give you $2,000 right now and I don't know how much this might cost me in the end. Where are we at with this? Oh, it gives a client a better sense of control about what they're doing, and so it also, I think, invests them more in the process if they know I'm going to do that they're going to get a particular piece and they may have to do the rest. Also, and I think it's later on in the slides, we talk about when you do limited scope, you may sign on to do one thing. And you do that thing for the client, and then they come back and say, well, I want some more. And that's your opportunity to educate them about where they are in the process and what's going to happen from there, and get them a little bit more invested in what's going on, and help make sure that they understand a little better what's going on. Are they happy with it? They get a better sense of, if they know your end product is not going to be that you're going to get them their money, your end product is going to be that you're going to present them with a letter that's going to be sent to the other side. They're not expecting the result, they're expecting the letter. So, they, I think, are more in touch with what they're going to get. And that leads to them being more satisfied. In other words, if they're clear on their expectation of what they're going to get, and they get that, they're going to be happier. So I think the question to, are clients happy with limited scope representation? Absolutely. As long as they know, going back to the beginning, as long as you have that agreement of what they're going to get out of it, and you're both on the same page with it, I think they are going to be, by and large, happier. Now, certainly, if somebody has a complex case and you're going to do a little piece of it, in the end, if they don't get what they want, they may not be happy. But if you were clear that what they were going to get from you was an appearance at a hearing or help with a mediation, they're going to be satisfied with that piece, hopefully, that you did for them. By the way, I should have said at the very beginning that if anybody has questions, feel free to let me know and I will pause and take questions as we go along. I've stressed a little bit about how important it is to have a retainer agreement. Let's talk about what those need to be like. So you have your standard retainer agreement. It's probably 4 or 5 pages long. You may go through it with clients, skim through and tell them the high points. They're never actually going to read it. They really don't have a clue what's in it. What do you put in it? Well, probably what your malpractice insurer told you had to, and what you put in there because something bit you in the butt before because you didn't have it in there. But it's supposed to lay out the relationship between you and the client, and it's going to include a lot of a language that, like I said, only you and maybe the malpractice insurer ever read. but it is also supposed to explain to the client what you're going to do for them. How is it different with a limited scope retainer? Well, with a limited scope retainer, you really need to sit down with the client and go through the whole thing in detail and explain to them what you are doing, make sure they understand it, explain to them what you're not going to do, equally importantly. And then also, if there's something that the client is supposed to do, you have to bring me this piece of information before I can write this will for you. You want to spell that out in the retainer agreement as well, what they're going to do for themselves or what they're going to do to help you out. So I don't know how visible this is for you guys, but it's a sample retainer. It's a sample of the retainer I actually use if I meet with somebody in person. And I'm gonna read it to you. It says, it's written up as if I was the client, and it says, I, Ed Higgins, hereby authorize Montana Legal Services Association to help me with the following. And then the underlined part that's been written in, assistance with drafting my answer in Missoula County Justice Court, cause number CV00000. I understand that I will be representing myself through the rest of the court process, including mediation and any hearings. MLSA will not be appearing in court on my behalf, right? So pretty clearly this says to somebody that we're gonna be helping them write an answer in a particular court case. I will tell you that often when I do these, there's also a date on it. I'm gonna meet with you on this date. I'm gonna help you draft this answer, and then you're on your own. And then the rest of this retainer agreement goes through and says, things like, number one, legal services is not agreeing to do anything that's not listed above. So we try to be very thorough with the retainer agreements. So I love quizzes in presentations. I may make somebody answer. Would it be good enough to say, attorney will draft pleadings for eviction action? Attorney will not appear in court. What do you guys think? Would that be good enough for a limited scope retainer agreement, just to have something like that?
No,
Who said no?
I said no.
All right, well, I think you're right. I think if you have to ask yourself, is it good enough? The answer is probably no. So what might be better? Better example of this? Listing out the address of the property that we're dealing with, saying what court we're in, who the tenant is that we want to evict, even when the tenancy started, and then going so far as to say, we're going to draft this, but then I'm going to sit down with you for 2 hours, talk about court rules and procedures, how to conduct the hearing for the action for possession. Real specific. And then on the will not part, if you're in justice court in Missoula County, there's probably going to be a mediation. I'm not going with you. I'm not going to correspond. I'm not going to talk directly to the tenant. I think that's really important. Like, I'm letting them know who you're willing to communicate with, and make it clear that you're only going to draft in this case the summons and the complaint for possession. And that you're not going to do anything else. You do want to be pretty specific, and you want to make sure you sit down with the client and you go through it, right? Because the client has to understand what you're going to do and what you're not going to do.
Now, excuse me, but isn't the second part of the first paragraph advising a layman how to practice law?
I'm not sure that is when you're advising them how to represent themselves. When you're specifically saying this is how you can represent yourself in this situation.
You're more telling them the rules and procedures
Yeah.
of the court so they know how to conduct themselves in the case.
Advice on court rules and procedures, how to conduct justice court hearing.
In the action for possession. Now, you're right, this could be more specific. You could, I probably should have said advice on how to conduct this specific justice court proceeding.
Or general advice on how proceeding proceeds.
Yeah. On the procedures.
Yeah.
Yeah. I could have been more picky. You're right. Rats. I'm gonna have to go home now and be picky.
Sorry.
Well, the will not is hard too. At some point, you know, I will not go to your house and clean your toilets either, but
You know I told you there's this sample that's like a 4-page checklist. It almost gets to that level with the will nots and things that you check off. Because it really is based on, if you look at the checklist, it includes, and it's for a family law case, it includes anything that could come up in a family law case. So it is almost to the level of, I will not go to your house and clean your toilets. You know, you could decide if you did want to go clean the toilets. You could decide to do that. So, also in the handouts, there's a sample retainer, and there's a attorney-client checklist for tasks. And if you're really interested in this stuff and you want to see a bunch of examples, I'm pretty sure this link is still good to www.unbundledlaw.org, which is nationwide. People who are interested in unbundled services or discrete task representation or limited scope, as we call it in Montana. I love questions like this. I love actually answers. Do you always need a retainer for limited scope? Yes, unless you don't. Because the rule says there are 3 instances where you don't. Somebody calls you on the phone and says, I just have some quick questions. Now here I would pause and say, if somebody calls you on the phone and says, I just have some quick questions, if we're doing this as a model of how to make money, answering those questions over the phone may not be a great way to do it. But if you say to the person, wonderful, why don't you come down to my office? I'll be happy to answer the questions for you. And then you have that opportunity to get payment up front before you answer the questions. We're still in good shape. But you don't have to have a retainer according to the rule if you are only doing a phone consultation. And then my personal favorite is that if you're participating in a court-annexed program and providing information, advice, or helping fill out court-approved legal forms, you don't need a retainer agreement. That would be if you're helping with an advice clinic in your local area. And a lot of the local bars or local courts across the west and southwestern portion of Montana now have these clinics that you could participate in for family law. There's one here in Missoula, there's one in Helena, there's one in Bozeman. They just had the first one that up in Great Falls. There's one that happens quarterly in Kalispell. So there's a lot of opportunities to get involved with pro bono with that if you wanted to get into that and not need a retainer agreement for doing it. And then if you're appointed by a court for a limited reason and the order specifically limits what you're supposed to do. I don't know that we see this a lot in the civil arena, but I think sometimes in the criminal arena there are some pretty limited appointments. But if the judge tells you you're only on the hook for something limited, then you don't have to have a retainer agreement. What would I do if I got one of these? I would still do a retainer agreement. If the court said to me, I want you to do this limited thing, I would still want to sit down with a client and say, hey, the court told me to do this limited thing. Here's what I think I'm supposed to do. Here's what I think you're supposed to do. Let's sign this saying that this is what we're going to do together. I actually, in the third one, I would still want a limited retainer agreement. Okay. Can you do too much? Well, the question is not, can you do too much? If you can figure, if you're getting paid for it, you probably can't do too much. But if you want to do limited scope, you need to be careful in that if somebody comes in and they say, I just want to ask you some questions, and you do your limited scope or retainer that says you're just going to answer questions on this subject, on this day, at this time. You're limiting what you're gonna do just to answering these questions. And then the person comes back and they say, I'd really like to have you write a letter. You wanna do a whole new limited retainer agreement that says, I'm gonna write this letter for you. Which means if somebody comes back and they want help with more than one discrete piece, you're gonna have multiple retainer agreements. And that's okay. That's a good idea. Because then nobody can later come and say, weren't you really doing full representation? I mean, you did so much for this. No, I wasn't doing full representation. Every time the person came in, I said I would do a limited discrete thing and we had an agreement. And here they all are in this file, all of these discrete agreements. I showed you the sample that I use, and when I have people come in multiple times, I have that retainer agreement filled out in multiple ways. Even if they're just coming back for more advice, I'll have an agreement for each time they come back. Even if I'm just answering questions each time. It's I think a really good way to protect yourself. And again, if it's the situation where you're having people pay in advance for what you're doing, you're collecting that money each time you do that separate retainer agreement. What happens if you don't? Well, if you have a limited retainer that says, I'm just gonna give you advice, and then the person comes back and you write a letter for them, and then you help them draft some pleadings, and then you say, oh, I'll go to that mediation with you, you may find yourself kind of on the hook for full representation when that wasn't what you signed up for. So you want to make sure that you have a good understanding in writing with the client about what you're doing. Can you do too little? Well, as long as you do what you said you would do in the retainer, no. But you also want to make sure the client knows when you're done. And this is especially true if you're going to appear in court. Say you agree to appear at one hearing, you want to make sure, and the rule actually requires you, and we'll hit on this later, but you want to make sure that you're filing something with the court saying that you're done. But you really, even if you're not appearing in court, when you think you're done, you want to let the client know in writing that you think you're done. And if they don't think you're done, well, they'll come back and tell you that. But you want to let them know that you're finished. Okay. And this is what I was talking about with the rule. Rule 4.1, 4.2 say that you've got to, if you're making a limited appearance and you're actually appearing in court, you have to file and serve a notice of completion of limited appearance. So if you're going to just do, I'm just going to do that one hearing for you. You want to go do the hearing, have that notice that you're done, and file it when you walk out of the hearing, right? You don't want to wait till tomorrow, because that client will come back and say, couldn't you just do, no, you file that when you walk out of the hearing. Get yourself, if you want to be out, you want to be out and do it quickly. But one of the concerns when, back in 2010, 2011, when this is being discussed, one of the concerns by a lot of attorneys was, what if the judge won't let me out? If you look at the structure of these rules, right, there is nothing permissive about this. You don't ask leave to get out, you file a notice that you're out. So in theory, the rules are written so that the judge doesn't have the discretion to keep you in if you have agreed to be out.
Isn't the client normally consenting to you being out?
Well, yeah. I mean, that's part of your retainer agreement. They're consenting to you being out. And of course, you tell the court, I'm only in for this one thing. And then you tell the court, I'm done with that one thing. So you're real clear with everybody, limited, done. But the idea is that it's not, if the client has consented to you being out, there isn't the option for the judge to say, I really think this person needs to have representation and you're on the hook now. No, if you've done this right, I suppose the judge could come back and appoint you. But We will hope that doesn't happen.
They can guilt you into it.
Yeah.
Oh, they'll, yes. I'm talking about rules, not guilt. So one thing that we need to talk about is, I'm a big believer in limited scope. I do a lot of limited scope. What if you've got a client and you're not sure whether they can understand the idea of, I'm only going to help you a little bit, right? That's a situation where if you question the client's ability to understand that you're only going to help them a little bit, one, got to think about their competence in general. Are they really competent to contract with you to represent them? And two, if you think they could probably hire me to represent them, but I'm not clear that they really can understand that I'm just going to do this limited thing, that may be a case where you shouldn't be doing limited scope. Okay? I will tell you that a couple years ago now, I had a client in a pro bono case, doing my pro bono work, and he had some cognitive limitations. Among other things, he didn't know how to read. I don't think that it was completely that he did not know how to read. I'm not sure that he had the cognitive ability to learn to read. And I would have been extremely uncomfortable saying to him, I'm only going to do part of your divorce, because I'm not sure he could have really understood that. So you have to make that assessment, and there are going to be times when you say, I'm not going to do limited scope for this person because they aren't really going to understand what that means. That may mean that you're not going to help them, or it may mean that you're going to help them completely. So, but I think in terms of making the decision, can I do limited scope, you have to realize that there's a difference between competent to contract with you and competent to understand that you're going to help them in a limited way. So, can they understand the limited representation? Some things to think about. When we're talking about family law, this one comes in a lot. Extreme emotional stress. And again, my guy a couple years ago, cognitive impairments. But also, are we helping somebody in a situation where perhaps their judgment about this stuff is going to be impaired by use of drugs and alcohol? Important stuff to consider. Are there other factors that would make a case unsuitable for limited representation? I think the answer to that is yes. There are certain cases, I think, where no matter what you do, they're just simply too complicated to do a little piece for somebody. I had a conversation with an attorney here in town a few years back, and I said, I've got this person, and really what they need to do is a quiet title action, quiet title to some real estate. And I was talking to a guy who was a real estate attorney, and I said, do you think it would be possible to just help somebody out with drafting a complaint for a quiet title action and let them do it on their own? And he looked at me and he said, Ed, theoretically it's pretty simple, but there's a lot of opportunities to mess it up and have it become super expensive. He said, I wouldn't be comfortable with it. And I think that's an illustration of maybe something where limited scope could do more harm than good. Is there extensive research required? Are there some sort of special procedures? Are the stakes perhaps too high? I think about bankruptcy, for example, where you can get into a contested proceeding in a bankruptcy case. And maybe if you're looking at somebody's bankruptcy case and you're thinking there's going to be some sort of contested proceeding within that bankruptcy, maybe just doing their bankruptcy forms for them is not a good idea. And you're either gonna have to make the decision to help or not help. And then, are there simply just risks that are too high to make it reasonable to limit the scope of what you're going to do. And that's more, I think, a case-by-case basis. I don't know that I have a good example for that one. So, if at the beginning of this you had asked me, as the instructor in that class that I was helping with an hour or so ago did, what is it you're going to talk about limited scope? I would have said how important it is to have a retainer agreement. How important it is to make sure the client understands what you're going to do for them if you're going to do limited scope. But I got a couple other points. There's money in limited scope. It's a way to serve more people if you're interested in having more clients. It's allowed under the rules. It is helpful to people, especially people who can afford to pay for something but not full representation. But it's not always a good idea, and part of your competence is going to be in assessing whether or not, in the particular situation that you're in, it is a good idea. Is it a good idea to do limited scope for Indian wills? Absolutely. But here's some things to think about. If you're going to do them and do them on a pro bono basis, you probably want to make sure in your list of things you're not going to do that you say, I'm not going to store this will for you. Right? I'm going to give it to you, and then it's up to you to make sure it's in a safe place and it gets to all the people who are going to need it. Because otherwise you might end up storing a bunch of wills. And you might not want to do that. All right. That's the end of my slideshow. I was doing my best to go quickly so that we don't actually have to go to 4:30 because they made me last. And I like to give people a bonus. Does anybody have questions about limited scope? Anybody want to challenge me on anything I said?
Has any of this been litigated in the Montana Supreme Court, and what cases related to limited scope are out there supporting it or otherwise?
To the best of my knowledge, there haven't been any cases on it in front of the Montana Supreme Court. There's been relatively little litigation on it on a national basis. And as far as I'm aware, it pretty much comes down to the idea of, as long as you have a retainer agreement and it spells out what you're going to do, you're good. But I will confess it's been a few years since I looked. Okay. Other questions? Don't tell anyone we got done early, especially anybody on the webcast. Yes?
Do you have any sense of how much limited scope representation is happening in Montana?
You know, that's a really-
Have any sense?
That's a really good question. I think that there's a set of people who are comfortable with the idea and were probably doing it before 2011. And those people are still probably doing it. I am unaware, there's a firm here in Missoula that does, they target their services at people who
Montana
Can-
Legal Justice?
I wasn't going to say that out loud.
Montana
But
Legal Justice.
they do some, part of their business model is limited scope. You know, you can buy an hour of their time. It used to be $60. I don't know if they've raised that price. And there's a couple other firms like that around the state. I can only think of maybe one other. But other than, one or two firms, I don't think anybody's really doing it as a business model. And I think it's more done in a piecemeal fashion. I would bet you there's a lot of solo practitioners in a lot of small towns who say to somebody, gosh, you could benefit from an attorney, but I know you don't have any money. Do you think you could afford to pay me this much to do this? Okay, let's do that. Because they're trying to help people in their community. But I think if you ask them, are you doing limited scope? They would say, no, I'm a solo practitioner in a small town. So I think it's pretty hard to get a feel for how much is being done. I don't know that the rule changes in 2011 really got a lot of people doing it outside of getting more people willing to do it on a pro bono basis. And I will tell you, at Legal Services, we have seen an increase of people who are more willing to do telephone advice or participate in the clinics as discrete tasks. Because it is, you know, if I come to you and say, hi, I'm from legal services and we really need you to do some family law, would you take on this really messy, ugly family law case and do full representation? You're gonna be like, oh, that's hard, that's a big commitment. But if I come to you and say, would you volunteer for 2 hours at a clinic and maybe talk to 3 people and give them some advice? Well, that's a much easier thing for you to do because your commitment is 2 hours and I'm gonna talk to 3 people. And I'm only gonna give them advice. So yeah, I think it's helped in the pro bono realm. I'm not sure people have really embraced it as a good revenue stream, which I think is too bad. Because there aren't too many opportunities that I have as someone who really pushes pro bono to come out and say, hey, you could make some money doing this. So, other questions? Yes.
Just one question. I know you opened the presentation by talking about malpractice, the possibility of malpractice, but for those of us who are like state employees and we are just trying to get involved for a pro bono basis, what are the different mechanisms in which we can be covered by MALSA or some other malpractice insurance and still be able to provide those services?
If you do anything on a pro bono basis and you do it through legal services, so if you participate in one of our clinics or you take a case, a full rep case, you get our malpractice insurance. So anything you do that comes through legal services comes with malpractice insurance. So, you know, clinics, direct rep, whatever, you know, doing advice over the phone, those are your avenues. As long as it came through Montana Legal Services, our malpractice insurance comes with it. And we have malpractice insurance from Lloyd's of London. Doesn't that sound swanky? I have no idea why. I always thought that was funny. Yes?
Can I add that Cascade County Law Clinic, also in Great Falls, they really need attorneys that are willing to do any kind of work that they're willing to do if they'll just call them to.
Yeah. Well, and the other thing about that is that if it's, because Legal Services has had a long-standing partnership with the Cascade County Law Clinic. If we've screened the person at Legal Services and they're going through the Cascade County Law Clinic, it's another way to get the malpractice insurance because it came through us in one way or another.
Cascade County Law Clinic does have.
They have their own too.
Yes, they have their own.
So you could get a couple layers if you really wanted to.
Like in Montana, that's really the thing.
Yeah, well, layers of insurance. Then the insurance companies could fight about who's going to be providing coverage.
I don't think it's Lawrence, London.
I was like, why do we have malpractice insurance from Lloyd's of London? We're in Montana. Shouldn't we have like done Alps or something? I don't know. But those are not my decisions to make. I'm guessing Lloyd's of London maybe was cheaper. I don't know.
So is that really the only way in Montana to do that? I'm just wondering if there's other.
So I may get in trouble for this, but here's the thing. If you find an opportunity to do some pro bono work and you think, I'm a state employee, I don't have malpractice insurance to do this, gosh, I'd really like to do it, you can run it through legal services. Because if you call us and say, I found this pro bono opportunity, I really want to do it, is there a way that I can do it through you guys and get the malpractice insurance? Unless you want to do it for somebody who's not eligible for legal services help, we'll screen them for eligibility and say, we referred it to you. Even if you brought it to us and said, can you do this so I get the malpractice? We'll get you the malpractice.
And that's the same with Cascade County Law Clinic. There's also Patty Payne with the State Bar Pro Bono.
I think everybody who's involved would rather have someone who wants to do pro bono have a way to make it possible than like be like, no, it didn't come from us, you can't have our malpractice. No. If you found an opportunity, we'll try and make it work for you so you get the malpractice. So I guess the key thing I would say there is you find an opportunity and it's not something that came from us, well, give us a call and see if we can run it through real quick and get it to come from us so you get the malpractice. I may get in trouble for that. Hopefully no one I work for is listening to me say that. I'm just kidding, I won't get in trouble.
I think I've heard that before, actually.
Yeah. No, we like I said, we'd rather have people give it, do something than think, oh, I don't have malpractice, I can't do this. And if you really are a state employee and you're worried about using state resources, if you're in a location where there's a legal services office, we'll let you come in and use our office. So sometimes we'll even help you with paperwork. We're pretty nice though. Anybody else have questions? Do I get to tell them they're done 15 minutes early? You're done 15 minutes early. Thanks for coming.